Hello everyone. In this video we will be discussing about Patents Act with an example of Bajaj Auto versus TVS Motors. A patent is the holder's exclusive right to use an invention, allowing him to enjoy a monopoly as well as benefits from its use. The Patent Act 1970 has provisions relating to the enforcement of patent rights and protects the interest of the holder.
Bajaj Auto Limited versus TVS Motor Company Limited is a landmark case of a dispute with regard to unauthorized application of the patent of the digital twin spark ignition, DTSI. It is an intellectual property of Bajaj Auto Limited. In DTSI technology, the two spark plugs at either end of the combustion chamber helps faster and better combustion.
All this starts back in 2002 when Bajaj filed an application for the patent of DTSI technology on July 16 in the Indian Patent Office. Bajaj also filed a PCT application, the Patent Cooperation Treaty. It is an international patent treaty which provides unified procedure for filing patent applications in contracting states. On October 30, 2003. On July 7, 2005 the patent was granted to the Bajaj Auto Limited.
There are two suits in this case. The first one was when Bajaj claimed unauthorized application of its patent, regarding DTSI, against TVS, at Chennai High Court, in 2007. For the relief of permanent injunction, under Section 108 of the Patents Act 1970, restricting from using the technology described in this patent for manufacturing, marketing, selling, offering for sale or exporting two- or three-wheelers, including the proposed 125cc flame motorcycle, containing an internal combustion engine. Plaintiffs also claim damages for infringement of patent.
While the suit was pending in the High Court, the plaintiff filed an application for seeking the temporary injunction for the same till the pendency of the suit.
TVS Motor Company brought a subsequent suit under Section 106 of the Patent Act in the same High Court, claiming that Bajaj is making groundless threats of patent infringement.
To this, the Madras High Court in contrary issues a temporary injunction restraining TVS to a limited extent, meaning thereby it could execute pending orders which were already taken, but couldn't take fresh orders.
Later to this order, TVS pleaded for vacating this injunction order and the division bench of the High Court agrees and vacates the order later. To this, an appeal was filed before the Honorable Supreme Court by the petitioners against the order of the division bench of Madras High Court.
Supreme Court expressed its unhappiness on the pendency of the case before single bench of Madras HC at the interlocutory stage for such a long time as the suit was filed in December 2007, and yet, even a written statement has not been filed.
Supreme Court said that as they have already observed in the case of MS Shrivardman Rice and Jen Mills vs. MS Amar Singh Chawalwala that the matters in relation to patent, trademark and copyright must be expeditiously decided by the trial court rather than disputing on the point of grading and refusing injunctions to each other. Such suits go on for years and years and are not decided properly, which is not a good practice. Supreme Court directed all courts and tribunals to follow this case judgment strictly, punctually and faithfully.
Hence, without analyzing the merits of the present case, the Supreme Court directed the respondent to file a written statement as soon as possible if not already filed so. The Supreme Court also directed the Madras High Court to hear the case on day-to-day basis. No adjournment order shall be granted and the suit shall be disposed of on or before 30th of November 2009.
The Supreme Court also directed the Madras High Court to appoint a receiver in this regard, who will keep all the records of the sale proceeds of TVS till the pending of the suit. The Supreme Court then dismissed the appeal.
The Madras High Court held that the patent right vests with the Bajaj Auto Limited as it has been manufacturing products using the patent technology since last 5 years. The court subsequently in paragraph 54 observed that it is also clear as per the decisions, for the purpose of deciding the novel features to constitute pith and marrow, a purpose of construction has to be given in order to make it essential requirement of the invention that any variant would follow outside the monopoly even if it could not have material effect upon the working of invention.
What we can say is that, in this case, the legal battle was fought for almost 2 years and was struggling between the interlocutory orders, which were making the legal battle of no positive effects for either party. The Supreme Court gave a landmark judgment in this case, ensuring that all cases in relation to IPR have to be completed within 4 months from the date of filing the suit and case should be heard on a day-to-day basis in order to follow the SC's direction. Thank you.